We'll take up D4, Mr. Hamlin.
Yeah, I had a request from Anna Holger to talk about her Standish Grange.
Okay. I can do that.
I guess they are.
I was here a year ago. In fact, it'll be a year ago tomorrow, and I figured you missed me, so I'm back. This time, I brought our charter.
Yay!
We are chartered. And we also, for our 86th anniversary, I haven't been there for 86 years, but Standish Grange was started 86 years ago. We're the first Grange in the state of California to get congressional recognition for our efforts. The first Grange. I'm so proud of us.
Anna, when did you get that?
April 25th, 2014, that was our anniversary.
That's
and
right,
it's from
that's right,
Doug.
yeah.
Okay.
Yeah, I got it.
But what I wanted to be, because I've had a problem with Jim Wolcott, not let my kids show at the fair. I contacted certain people, and I'm going to read this off. You have it in front of you. Anna, yes, there are no problems around the state with other California Grange youths showing at local fairs. The ruling of the Superior Court is that things are to remain status quo until the legal issues can be resolved between state and national. The trial is set for June 1st, 2015. Just this morning, I spoke with Jay Carlton, Ag Manager for California Exposition and Fairs under CDFA. They make up the rules. He said that there will be no problems for California Grange youth showing at fairs, and if there is, to call him. So can my kids show at the fair? My youth?
Well, Mr. Chairman, this was an issue we had last year, and I think the problem that the board had, and through the board the county had, is that we don't want to get involved in this dispute between the national and the state organization.
No.
And obviously, whatever was the dispute that caused the rupture, they went independent. And basically, the communications we had at that time, the National Grange had withdrawn its recognition of the State Grange Organization as one of the 50 Grange organizations in the country. And the Grange, you might say patent, or the Grange charter, or the Grange authority emanates from the national level to the state, not to the state to the national. And so as a result of that, that was the reason why I think the county took the position, at least Mr. Walcott did, in terms, and I think at that time there was some question even with CDFA, with the state folks, in terms of how do you recognize, and basically he required all the kids that would be involved through the Grange would have to show under the independent category, which, I think Anna's correct, it kind of puts them at a disadvantage. And I think basically it was incumbent upon the state Grange folks to establish their legal authority to be, to be recognized. And obviously that's what the litigation is about. What we indicate is we're not the judge, and we're not going to try the merits of this case and resolve this dispute. You need to go deal that with the courts. So based on this, I think that if indeed there's a Superior Court that's involved and they've issued a ruling in which they basically keep in place the existing status quo relationships until they sort out the differences between the state and national folks, I think that's good enough for me. And I think that obviously this Mr. Carlton should be contacted, and we should get all the documents that they have and make sure it's in the file so that there isn't any dispute done. But we're not going to try the case. It's not our job.
No.
But at the same time, the kids got caught in the middle of
Yeah,
that
it's not fair.
dispute, and I don't think we should
Exclude any kid.
Exactly.
No.
So personally, I think we should, Mr. Egan, if you could, working with Mr. Walcott, and maybe County Council can also assist in terms of making sure all this stuff is verified, and if this indeed is the representation, and there's a court case that and a judge has issued that kind of a ruling, that should suffice for the time being what we need in order to satisfy. So let the kids be Grange representatives.
They are. Yeah. Thank you. Oh,
Aaron?
Yeah, one of the things, you talked about the California Range crew used to showing. Now, is that just going to be a ring, or are they planning on showing the market animal and then turn around and selling it too? Because that might be some clarification that we might need too.
this year, I actually don't have any kids showing or selling, marketing, but because I have this clarification now, I want to settle it before I have to go through a fight next year, because I have 4 kids showing next year. And so far, they're just showing.
Okay. it might be good to talk, get the selling as well for clarification
Right.
under this.
Oh, okay, yeah, we can do that through that contact person, the ag guy.
It wouldn't hurt to have that all buttoned up so there aren't any
Absolutely.
disputes in the future. And obviously, the trial's gonna be set at some point next year. They'll probably have a resolution, and it may be that the courts will say that the state is out of luck, that they have to adhere to what the national organization dictates to them. And, but I'm all in favor of being independent.
Yeah, right now, we are independent. I'm a California Grange, not a national Grange.
Okay, any more questions from the public? Thank you for your presentation.
Well, I think,
Thanks for your
Well,
effort for the kids.
I think part of the,
Greatly appreciate
what
it.
the litigation is about, from what I understand, is the use of the Grange name. And is that, it's fine that the state of California puts that out as a charter, but the question is whether it's a legal, legitimate use for them to use the Grange name. And that's obviously what the court's going to have to resolve, and hopefully they will.
Well, since we're 86 years old, I'm going to use my Grange name.
Yeah, go right ahead.
Thank you, Jim.
Thank you.
Everybody happy?
Everybody's happy.
I'm ecstatic.
And we appreciate what you do.
Oh, man, yeah.
Oh, just
You know,
eating
I've been
cherries.
to several of her Grange, a few of her Grange meetings, and you
Okay,
guys do a good job there.
if no more questions, we're moving. Thank you for your presentation.
No, thank you. Like this can show.
We're gonna go down to, or move ahead to H1. Melanie, you're gonna start that?
Yes. Melody Crawley, Director of Health and Social Services, and I have with me this morning Phil Nowak, CEO from Northeastern Rural Health Clinic. And we're asking you this morning to, I'm recommending Phil to fill the commissioner position on the Partnership Health Plan of California Commission. Bob Edwards, former director at Banner Lassen Medical Center, had filled that position for us, and he resigned to accept the job.
He didn't last very long. He got the position and appointment within a short time.
Yeah, then,
He
yeah.
got cut loose, so hopefully Phil won't have that.
Not a curse.
Not planning to go anywhere.
Anyway, I've been working with Phil for a while now with the Lassen Healthcare Collaborative, and I think he'd make a great representative for Lassen County on that commission.
Okay.
We'd be happy to answer any questions, or Phil
I
would
would
be.
move Mr. Sherman.
Got a motion and a second.
I'll second that.
Motion and a second. Phil, do you want to say anything?
Well, I certainly thank the members of the Board of Supervisors. I think from the standpoint of where the largest area of interest is for the residents of Lassen County, it really does involve Northeastern as the primary care clinic. And from that standpoint, we take the role, however, is representing the entire county. From our development perspective, we're putting enhancements for additional services in Westwood. We have Doyle in our plans for this coming budget year. So from the standpoint that a close relationship with Partnership Health can really help that, because they're very innovative and they're looking for ways to support their rural counties. It's really part of the role I would expect to play in support of that.
Aaron, Phil, do you have a satellite office up in Beaver?
We do not. Mountain Valley Clinic, I believe,
Oh, you
is
have somebody else
Dave
up there?
Jones.
Okay.
So, in effect, there's a clinic, but not affiliated with us.
Okay.
Well, I've worked with Phil over this Doyle Clinic and above and beyond the call of duty to get that thing opened back up. And the community desperately needs that thing opened again. And I really appreciate the efforts that you've gone through personally.
Okay. Anybody from the public have any questions or comments? If not, we have a motion and a second. All in favor, say aye.
Aye.
Opposed, say no. Ayes have it. Phil, you're there.
Thank you.
Thank you, ma'am.
I'll report through Melody as far as developments along the way.
Thank you.
Thanks, Phil.
And thank you for moving it up the agenda so you can go back to work.
Right, we want to get back to work. I got that note, you know.
Thank you.
Thanks a lot.
Okay. We're gonna go to F1. Another fishing game. What's the tackle that? There's Don. Let Don
Good
go.
morning, Mr. Chairman and Board of Supervisors. I'm Don Armentrout, Lassen County Fish and Game Chairman. We were contacted, or a little background history for the rest of the folks. Assembly Bill 711 was passed last year. The governor is signing the bill, which would lead to a total ban of lead-based hunting ammunition in the state of California. Told the Fish and Game Department, Fish and Wildlife Department, the commission and the statewide commission to come up with a schedule for implementation which would end July 1st, 2019 is when the full ban would go into effect. The Fish and Game Commission sent us, or the Department of Fish and Wildlife sent us a letter requesting our comments on their schedule. Their schedule is 2015. There will be no lead hunting ammunition on state refuges and state hunting units. In 2016, ducks and small game go into effect across the state, and non-game, if you're shooting varmints. In 2019, it goes into effect across the state. We have responded to that, which is part of your package. But in that response, we told them the first thing was we needed a meeting in Susanville. So we have written you a letter and drafted a letter even for you to send to the Director of the Department of Fish and Wildlife requesting that they hold a public meeting here in Susanville prior to July 1, 2015. And that's where we're at right now. Our letter is on the back of the packet. It's our letter which addressed their schedule and some things we saw were missing. And we also provided them with a list because they had a pretty short list of underrepresented calibers, which there is very little ammunition for, non-lead ammunition for. If you're a hand loader, this act will not bother you at all. You just change the bullets, you're loading and go. And I'm a hand loader, so I'm almost home free. So, what we would like is them to have a public meeting and have you help us get them here.
Okay, questions for Don?
The only question I would have is in the letter, Mr. Egan, that there's a typo on the second paragraph. The big paragraph says portions of the 5 next year zones from all the way to the end of the line are found in Lassen County. There should be a period there where you begin the next sentence because it kind of reads kind of weird otherwise. And I think I figured out what is missing.
Duly noted.
If you could fix that, that'd be sorry.
Okay, we have a motion of approval.
I'll make the motion. Who wants to ask?
I'll say.
More discussion.
Yeah, I talked earlier about, the impacts of the other government regulations, such as the dam structure for road control, and the banning of lead ammunition is going to affect that for the small caliber, for your muskrats, for your beavers, for your ground squirrels, for your other burrowing animals, that if they take away lead ammunition, you are going to be left with absolutely nothing at all to control. I mean, the ground squirrels up in the Big Valley area are absolutely pathetic this year. The volume and the number of them is unbelievable. On my ranch alone, I can document because I've had guys come in with the Fish and Game, you got to get a permit to shoot out of your vehicle. But with the guys I've had come up, we've killed over 10,000 squirrels just on my place alone. And that's just my ranch. And I didn't even have guys even shoot a quarter of their ranch. There's other bigger alfalfa guys that have a way worse problem than they are. And if we lose that, then what are we gonna do? I mean, it's just more documentation, I guess, to bring in the wolves to help eat them, but that's going to help them out 6 months of the year, because what they can eat the rest of the other 6 months. I mean, there's gotta be something else in there, to comply with other, like I was saying with the dam thing. I mean, it's just, they keep taking our tools away from us. And I think it's a good idea to get those guys to come up there so we can try to explain it to them. And I hope we get the Fish and Game Commission as well as the Department of Fish and Wildlife to get both entities here.
Well, currently, 223 ammunition and non-lead, which Barnes calls it a grenade bullet, which really does a number on them. is available from 2 different manufacturers, from about 4 different manufacturers. 22 rimfire ammunition is only one manufacturer makes non-lead bullet, and it's a 17 grain bullet, and that's CCI. The other short-handed one is Upland Game non-lead shot sizes. Although at the trap range last week, the people showed up with some steel number 7, which is good for Upland Game, and then 17 caliber are short. But 223 right now there's about 3 or 4 manufacturers that make non-lead ammunition for it, which are designed for shooting ground squirrels and smaller critters. If you're really hurting, there's hand loaders around that shoot 22 250s and 220 Swifts that could come up there and do the number, because they can hand load non-lead. And the bullets are available, it's just getting somebody to load them commercially.
Well, and the other problem you have with the big rifle, you have a much farther trajectory,
Right.
so the danger and the risk goes
Yeah.
up dramatically. And as far as buying a rimfire, you can't even buy a lead rimfire 22 bullet. I would love to buy 22 bullets, but I can't find them anywhere. And the cost of this stuff is, I mean, as it is right now, I mean, with the 22, I mean, it's almost, I mean, it's ridiculous. I mean, if you know, shoot 70%, 10,000 squirrels, I mean, I'm just talking me. You know, I'm burning a lot of ammunition, and it gets expensive.
I was gonna say, if you're hand loading and you got 10,000, you better get started.
On my shoulder eardrums can't handle shooting 10,000 rounds with 223, I'm sorry.
Okay, if you're gonna shoot 22 ammunition till it goes into effect in 2016, before the,
I'll be done next week because I can't buy any more bullets.
well, because the state legislature hasn't quite passed the bill where you can't buy ammunition through the mail, I would order it. Midway USA has it, Cabela's has it, but in their stores, hoarders are coming in and buying it. I talked to a man at the Sportsman's Warehouse in Reno about that, and they have a huge part of their shelf, which is 22 ammunition. He says, we put it on before we open at 10, and at 11 it's gone. Because hoarders are buying that ammunition for the big revolution, I guess, I don't know.
Okay, any more questions for Don?
I would
I'd like to see this letter.
I would also suggest that we maybe add to the, in a sense, I mean, we're writing to them, but I think if we could CC the letter to Assemblyman Dolly and Senator Gaines, our legislative rep, because they're the ones that obviously voted no on SB 711. I know Brian spoke against it, and but it would be helpful to have their support to try to encourage these people to have this meeting here. So if we added, I wouldn't necessarily CC it to the governor like you normally do, but I would say we could CC it to them. That would maybe be
Well,
helpful.
we put the CC to Brian Dolly, but we left off Ted Gaines.
Okay.
Okay, if those changes, we have a motion in second. Okay. all in
I'd say
favor?
we have a work party up at Aaron's house.
Yeah, sounds
No, your principles and shoot squirrels.
Okay.
Okay, so all in favor, say aye. Aye. Opposed, say no. Ayes have it. Thank you, Don.
Thank you.
Okay, let's move on to consent.
Mr. Chairman, if I may, for just a moment, there was a late breaking request on behalf of the department that has an item on there as G9. We're asking that matter be withdrawn entirely from the agenda.
No, just off the agenda.
Oh, thank you. I misunderstood. Just to have that pulled.
Okay, we're pull G1, Mr. Spencer wants off, Mr. Spencer wants G13 off, Aaron wants G9, and two separate discussion on them four, so we'll vote. Okay,
Okay.
Bob, I just had a discussion with the sheriff, and so I'd like to, I don't need to talk on, I don't need to have G13 pulled.
okay, so
Okay. Okay, what's it down anymore?
it's G1, separate discussion, G9 and G10.
And I'd like to have, if we could, G4 and G7 for a while.
G8.
You guys are terrible.
G8.
Okay, maybe I'll just go down the list. What's left is G2, 3, 5, 6, 11, and 12. And 15.
Yeah.
Yep.
Those are left on.
And 13 also, didn't she withdraw her request to pull it?
Yes, well, 13 also.
She was doing it.
So that's all.
Are we straight?
I think so.
Okay, do you have a motion to approve them?
Yes.
Yes,
Second?
I'll second.
Okay, discussion. All in favor, say aye.
Aye.
Opposed, say no. Ayes have it, we'll go take G1 in suspension.
This is just a copy of an agenda on May 13th. Just so you can have it in front of you. Item I-1 was skipped over at the meeting. And we verified this by listening to the audio tape and also reviewing the videotape. The public was not afforded an opportunity to talk about this, and Can We Help had some questions about that agenda item, but there was no public comment. In fact, we just skipped right over it. We did file Brown Act complaints. Oops, sorry. And we asked that this be re-agendized. That was ignored, and no response from the CAO, county council, or anybody. You were all emailed these Brown Act complaints. It's just easier for us to distribute them that way. The letter in question, or the issue, agenda item 1I1, was in regards to an attachment, a letter from apparently, it appears that it was from Judge Verderosa, but Judge Verderosa did not confirm that that was in fact initiated by her. The one on the top is the letter from Judge, allegedly from Judge Verderosa, is the copy you can print from your website. The second one is a copy of the original document. And then the third document is her letterhead. What it appears, and this is what our question would have been on May 13th, had you discussed that item instead of skipping over it, was whether or not this document was initiated by the CAO and not Judge Verderosa. There's a lot of questions. It's not, one, it's not on her letterhead. Two, date has been written in. Three, the receiving date has been altered. And the CAO has signed or initialed it as concurring with it. So the question today is, obviously you're not going to re-agendize it. We've waited a long time for you to do that, and you're not going to do it. So our question would have been on May 13th, did the CAO write this, send it to Judge Verderosa, and she sent it back in this condition?
Ma'am, I have a question. Can you help me understand what that has to do with the agenda item related to
The minutes.
proposed minutes of May 27th?
The minutes are wrong.
of May 27, the proposed minutes that are included on today's agenda?
May 13th.
But we're talking about May 27th, that's the item that was just called.
May 27th,
Yes, ma'am.
I asked for this to be put in there, added to it, and it doesn't make any mention of me asking for this to be re-agendized.
So that's how it relates to the minutes of May 27th.
Right.
Thank you.
So
Okay.
it's a simple question. Did Mr. Egan initiate this? Because it's a simple question. Nobody's going to go to jail over it. Nobody's going to get yelled at. It's just, did he initiate, this document originate with the CAO? And she commented and it came back.
I'll let Mr. Egan comment.
Well, if I may, you're not, Ms. Spencer, good morning. You're not suggesting
I like
that.
your shirt.
Thank you very much. You're not suggesting that someone signed Judge Verderosa's name, are you?
No.
Okay, thank you. I wanted to
No.
make sure.
The
that-
court verified her signature.
All right, very good.
The letter memorializes discussions that I and other personnel staff had with Judge Verderosa. I believe that my staff drafted the letter, although I can't confirm that
It looks like it.
without asking. And then they forwarded it on to Judge Verderosa, who signed the letter, sent it back, and then I signed it. So maybe that solves the vast
No,
mystery.
it was just a question we would have asked on May 13th, but it was skipped over, and that was the only clarification.
Just for a point of, on May 13th, we did review the minutes. I asked the clerk's office to review the tapes, and indeed, Chairman Wassick at the time did reference the letter.
No, he didn't.
I can tell you, if you call me, I can give you the information on where you can find it on your CD. I did find it. People were talking in the audience at the time, so might not have heard.
I know you're wrong because I've watched the video and the audio. So it's really, the question has been asked, you've had an opportunity and you've answered it. That's all.
But more to the point on the agenda item, the proposed minutes that Madam Clerk has offered, page 5, in the minutes from May 27, reference in the first full paragraph under consent calendar, Ms. Spencer requests item G1 minutes of May 13, 2014, and G2 administration purchase of IT equipment removed for separate discussion. That's noted in there, and so there is reference to that. And so, did we miss something there?
It also mentions at the bottom of page 5, too, Mr. Burke.
Thank you.
I missed that, thank you.
So the issue, Mr. Spencer, is that letter was not acknowledged in these minutes, so you're against us approving these minutes, but it is in the minutes.
No, it was clarification, Mr. Pyle.
But like Bob said, on the bottom of page 5, it says, Eileen Spencer claims the correspondence from Judge Verderosa regarding appointment of acting chief probation officer was not discussed at all. Is it?
And it wasn't,
Right, and so do the minutes accurately reflect what you said?
yes.
Okay.
But on the top of page 6 is Deputy Clerk Osgood states she believes it was brought up by Chairman Wassick and the letter was received and then discussion was held. And that's, and then Chairman Wassick states anyone had ample time to discuss the item under public comment if there was an issue. So in the minutes of May 27th, there was a fair amount of discussion about this issue. So I think that needs to be said from what it's.
The only thing I would take issue with Mr. Chapman is that the audio and the video clearly show it was never discussed. You can't just say, oh, we have 6 agenda items left and then adjourn the meeting and leave. And that's what happened. That's what the audio showed, that you talked about the stuff that was left on the agenda. Mr. Wazick was in a hurry. The
And
adjourned meeting left.
are you suggesting in the minutes and the discussion of May 27th is inaccurate?
Yes.
Okay. That's all we need to know.
In what regard? I'm not.
Well, she's saying that what is reported in the minutes in that discussion, it's not just her comment at the bottom of page 5, it's the rest of everybody else's comments responding to that at the top of page 6. So she's asserting, I guess, that that is incorrect. I would have to say we spent more time talking about this item than probably the judge and ever talked about keeping the appointment going for another 6 months, so
There's another
that's,
issue.
yeah.
Do we have a motion to approve G1?
Yes, so.
Second.
I'll second.